Okay. Good afternoon. My name is Miriam Aliso. I am from the Center for Parent Information and Resources, and I welcome you to the OSEP Discipline and Behavior Guidance Part 2 webinar. Okay. Before we start, I want to walk you through some features on the Zoom platform. Please, you can use the Q&A feature to ask questions. You can also use the chat box to communicate with the presenters, and if you have any technical issues. And we also have closed caption available to you. If you just click on CC, it will be activated over there. And también tenemos interpretación al español. Para acceder al canal en español, van a ver en la banda o cinta negra un globo que indica Interpretation. Haga clic allí y luego seleccione español y oprima donde dice Mute Original Audio. Esto último filtra completamente la presentación en inglés para que puedan escuchar con claridad a nuestra intérprete Mónica. Okay. Pass it to you, Carmen.
Hi, welcome everyone to part 2 about the discipline guidance that OSEP released. There was a lot of interest in part 1, and we wanted to follow up with some additional information. I'm joined by 3 colleagues from the Monitoring and State Improvement programs, Keisha Blythe, Kim Himes, and Lisa Pagano. So I'm going to just sort of turn it over to them and have them go through a lot of the questions you submitted around this discipline guidance. So Keisha, take it away.
Thank you, Carmen. Good afternoon, everyone. So as Carmen stated, I am Keisha Blythe. I am a state lead in the Office of Special Education Programs. I want to thank you again for joining us for the second part of our discussion about OSEP's recently released guidance about IDEA's discipline provisions. So again, as you heard, joining me today will be Kim Himes and Lisa Pagano in OSEP as well. Today's webinar is a follow-up to our time together last month when we provided an overview of the guidance, but ran out of time for questions. Today, we will have an opportunity to answer many of those questions. So thanks again for submitting. Additionally, please use the chat feature to continue asking questions, and we will do our best to address them. So again, joining me will be Kim Himes, who is also an OSEP state lead, and Lisa Pagano in the OSEP policy specialist, and there are our email addresses. In our time, oh, next slide, please. In our time together today, we wanted to provide you with a couple of brief updates and then dive into the questions that have been submitted to us. These questions generally fell into the following categories: addressing proactive and reactive approaches to behavior, including the use of FBAs and behavior intervention plans; change in placement, what is it, what counts, and why is it significant; informal removals, including shortened school days; and parental rights and procedural safeguards in the context of discipline. Next slide, please. All right, first we wanted to share the links to where you could find the Spanish version of these 3 documents that comprise the guidance package: the Dear Colleague letter, the comprehensive guide and answer document, and the technical assistance guide, which is titled Positive Proactive Approaches to Supporting Children with Disabilities, a Guide for Stakeholders. To find these documents, please visit www.idea.ed.gov, then go to the Resources tab, select Topic Areas, seen here in the top red box, and then select Discipline Behavioral Supports, seen in the bottom red box. We will also drop a direct link into the chat. Second, we wanted to share resources provided by PAVE on discipline, disability rights, and behavioral health. We will drop these links into the chat as well. Next slide, please. Before we jump into the content of today's presentation, we wanted to share a little bit about the format on the slides. As we shared, we have grouped the questions into the 4 topic areas mentioned earlier. The questions on the slides are those that have been submitted to us by you and that we have been asked and thought were relevant for today's conversation. Throughout the presentation, we will drop links into the chat for you to have for future reference. So let's jump in. Next slide, please. I'm going to go ahead and get us started. So the first question, schools are shortening their day due to behavior concerns, but not coming up with plans for them to return or providing education after being sent home. Can you please speak to this issue? So under IDEA, the vehicle for providing FAPE is through an appropriately developed IEP based on the individual needs of the child. In the case of a child whose behavior impedes the child's learning or that of others, the IEP team must consider and include in the IEP the use of positive behavioral interventions and supports and other strategies to address that behavior. Shortening a child's school day to address behavior, if implemented repeatedly throughout the school year, should be determined by the IEP team. An appropriate modification should be incorporated into the IEP by the child's IEP team to ensure that the child continues to receive FAPE. Shortening a child's school day outside of the IEP team decision-making process would be determined an informal removal. The practice of shortening a child's school day as a disciplinary measure could be considered a denial of FAPE if the child's IEP team does not also consider other options, such as additional or different services and supports that could enable a child to remain in school for the full day. So see C6 of the technical assistance document, of the Q&A document, my apologies. So you have a right to request an IEP meeting to request behavioral assessments, supports to addressing your child's need. The child's school must give prior written notice to the child's parent whenever it proposes to initiate or change or refuses to initiate or change the educational placement or evaluation of the child or the provision of FAPE to the child. The prior written notice must describe and explain the action or plan of action that the school proposes to take, including the reasons why and the basis for its decisions, for example, reports, data, etc. Lastly, a child's parent has the right to use IDEA's dispute resolution procedures, state complaints, mediation, and due process complaints to resolve concerns regarding the provision of FAPE. Next question. We are still encountering difficulty with LEAs misunderstanding the intent of the guidance. They are refusing to consider how disability is related to behavioral expectations and whether additional supports are needed until they reach the point of the manifestation determination hearing. Despite quoting from your documents, they mostly respond with, "We are allowed to do this and we don't have to make any changes until we get to the manifestation determination hearing, even though we have a plan to address the behavior and the plans was not followed. How can we help them see the damage this causes to the student and the lost opportunity to help them early in the process?" So IDEA requires the public agency to conduct an evaluation of a child with a disability or suspected of having a disability that is sufficiently comprehensive to identify all of the child's educational needs, including any behavioral needs. So, information it needs to develop an appropriate program for the child, including services and supports for the child and school personnel on behalf of the child to provide FAPE. IDEA regulations require IEP teams to follow certain procedures to ensure that IEPs meet the individualized needs, including the behavioral needs of children with disabilities. Once the IEP is developed, IEP teams must, 1, review the child's IEP periodically, but not less than annually, to determine whether the child's annual goals are being achieved, and revise the IEP as appropriate to address any lack of expected progress towards the annual goals of the child's IEP and in the general education curriculum. The results of any reevaluation, information about the child provided to or by the parent, the child's anticipated needs, or other matters. As OSERS noted in its 2016 Dear Colleague letter and the recent discipline guidance, the failure of an IEP team to consider and provide for needed behavioral supports through the IEP process may result in a child not receiving a meaningful educational benefit or FAPE. It is important for state education agencies, local educational agencies, schools, and early childhood programs to invest time and resources in ensuring that educators are equipped with the skills and supports, including evidence-based training and professional development necessary to implement appropriate strategies to address behaviors. The OSEP-funded IRIS Center offers modules on classroom behavior management and strategies for addressing challenging behavior. We will drop that link about the IRIS Center into the chat for your reference. So next question, how do we get administration support to help principals understand there are options other than exclusion or addressing a child's behavior? Again, as OSERS noted in the 2016 Dear Colleague letter, and recent guidance, the failure of the IEP team to consider and provide for needed behavioral supports through the IEP process may result in a child not receiving a meaningful educational benefit or FAPE. In addition, an LEA's failure to make behavioral supports available throughout a continuum of alternative placements, including a regular education setting, could result in an inappropriately restrictive placement and constitute a denial of placement in the least restrictive environment. It is critical that IDEA provisions designed to support the needs of children with disabilities and ensure FAPE are appropriately implemented to avoid an over-reliance on or misuse of exclusionary discipline in response to a child's behavior. Next question, is a behavior intervention plan considered part of an IEP? The IEP team determines whether a child needs a positive behavior intervention plan. So if a student's behaviors are interfering with his or her learning or that of others, the IEP team should consider the use of positive behavioral interventions and supports and other strategies to address that behavior. So in OSEP's letter to McWilliams dated 2015, for a child with a disability whose behavior impedes his or her learning or that of others, and for whom the IEP team has decided that a behavior intervention plan is appropriate, or for a child with a disability whose violation of the Code of Student Conduct is a manifestation of the child's disability, the IEP team must include a behavior intervention plan in the child's IEP to address the behavioral needs of that child. The above guidance clarifies that while IEP teams are not required to include behavior intervention plans in an IEP outside the context of a manifestation determination, IEP teams may elect to include behavior intervention plans in other circumstances, such as when they deem a behavior intervention plan necessary for a child whose behavior impedes his or her learning or that of others to receive FAPE. All right. And then last question, how should or must a behavior intervention plan be included as part of the manifestation determination review process? So a behavior intervention plan is required by IDEA when a child has been subjected to disciplinary removals that result in a change in placement. The IEP team determines that the behavior that resulted in the disciplinary removal is a manifestation of the child's disability. And if so, then the IEP team must either conduct a functional behavior assessment if one has not been done, or review it and develop a behavioral intervention plan. Or if one is in place, review and revise the existing behavioral plan as needed to address the child's needs. So I'm now going to forward it over to, or turn it over to Lisa Pagano to talk to you about change in placement. Lisa?
I am here. Thanks everybody for joining us today. I'm a little under the weather, sucking on a cough drop, so bear with me. If we could advance the slide, please. And thank you so much for submitting your questions in advance so we could tailor this presentation a little bit more to the burning questions that are coming up for you guys. And I want to invite you, we purposely set up the chat so folks can have a conversation with one another while this is going on, hopefully about the content we're discussing, and not the best place to get coffee or whatever, but to hear or be able to read and see what other kinds of things are coming up for you, if there are ideas or issues that you would want to share. We know that there are still lots and lots of challenges around properly implementing this guidance. And so to the extent you guys have any helpful hints or tips to share with your colleagues that may be helpful in their work. So you'll recall the last time that we got together, I spent quite a bit of time talking about change of placement, because this really is what triggers the disciplinary protections for children with disabilities. Until there is a change of placement for disciplinary reasons, you don't get to the point of having a manifestation determination meeting. The parent doesn't receive a written notice. And so it's really critical that school personnel have a good, solid understanding of what constitutes a change of placement for children with disabilities. It's really important in your work with parents that they get an understanding and go and look at their procedural safeguards document to read about what is a change of placement, and when that occurs, what rights kick in for them and their children. So again, during our last time together, even though I'm not a cooking or baking kind of girl, I talked about this in terms of a recipe, that there are different ways to get to a change of placement. One way is, for probably the easiest way to get to a change of placement, is when a child has been removed for more than 10 consecutive school days. So 10 days more than 10 days in a row. So 11 or more days, right? Consecutively. That by itself constitute a change of placement. That would be automatic. But we also have another way to get to a situation where a child has had a change of placement due to discipline reasons. And those three ingredients to the change of placement recipe, when there's a pattern, are detailed in the second bullet. And we need all three of those ingredients in order to actually create a change of placement. And so the three ingredients that we need to have in place is when a child has been removed had a series of removals, and that series total more than 10 school days, and they are not consecutive, right? And I'm seeing a note in the chat about consecutive versus cumulative. So two different ways. First way is a removal is for more than 10 consecutive in a row school days, automatically a change of placement. The second way you would have a change of placement is when all three of these sub-bullets are present. Over a period of time, the series of removals get you to that more than 10 school days. Not necessarily consecutive, But when you total up the separate removals, it's more than 10 school days in the same school year. The second ingredient is the behavior for which the child is being disciplined is substantially similar to the behavior that they did in previous incidents that got them put out of school. So that's the second ingredient. The third ingredient is looking at factors such as the length of each removal, the proximity, how close to one another these are, excuse me, and looking at the total amount of time the child has been removed. So in the chat, how many of those three required ingredients would you say are objective determinations? Of those three sub-bullets, how many are objective? Come on, this is your time for participation, folks. Let's see some answers here. One. Two are objective. One. Okay. All right. So we might have consensus around one of them being objective, and I would agree that first one, any person should be able to reach the same conclusion about whether or not the child has been removed for more than 10 school days. When we start looking at the second bullet, is it substantially similar? Is it kind of close? Is it not exactly the same? We might run into a situation where there might be a difference of opinion. The additional factors, the length of each removal should be objective. The proximity would be objective. The amount of time would be objective, but deciding on the impact of that could be subjective. There we go. Look at this. All right. So now we can't even agree on bullet one. Okay. Excuse me. But so this is, I raised this to show that this is a really important decision, because school personnel are deciding this. They don't have to decide this at an IEP team meeting. You may have the assistant principal or other designated school personnel who's deciding, okay, we've put this kid out a few times. Is this a change of placement? Nah, I don't think so. So we don't have to worry about doing a manifestation determination. We don't have to give the parent notice that we decided it was not a change of placement. So you can see why keeping track of removals is so important, so that parents have an awareness and that they can ask the right questions if they believe that their child has experienced a change in placement due to these multiple removals or the extent of their child's removal. So just wanted to give a flavor for that kind of thinking and how you might convey this to parents as you're talking with them about whether there's been a change of placement. Because remember, we don't get to manifestation determination until someone has decided there's been a change of placement. Now, in OSEP's guidance, we say, you know what, you don't have to wait for a change of placement to hold a manifestation determination review. There's nothing in IDA that prevents you from meeting as often as you want to talk about these discipline kinds of concerns. But under IDEA, the regulations themselves, a manifestation determination review is only really required when a child has been subjected to disciplinary removals that constitute a change of placement. So the last bullet, I'm going to give you a non-answer. We've gotten a lot of questions about, so how does this count? If they're just removed from a special, does that count? If they're just removed for a half an hour, does that count? OSEP has not provided any specific guidance on the actual calculation of removals in little bits and pieces. What we have asked is that states provide guidance to their LEAs. They're going to want to make sure that their LEAs are applying this and working in a consistent manner when they are looking at making informal removals of children or removing children for certain portions of the school day. Perhaps in the future there will be something we will do on this, but right now there's really not a specific answer we can provide to you about that. If I had questions and I worked in the state, I would likely reach out to my SEA and say, so OSEP said this, what are you telling your LEAs about how to handle, informal removals and how to count these kinds of reassignments. And I know Kim's going to talk to us in more depth about what is an informal removal and the criteria for that. If we could go on to the next slide, please. Okay, so here's another chance for us to agree to disagree, probably. Just thought we'll put on our thinking hats. So change of placement is outlined in 300.536. Excuse me, that's where the regulations lay out. They don't call it a recipe like I do, but that's where they lay out the different factors that must be present in order for there to be a change of placement due to disciplinary reasons. Uh-oh, what happened to there's my Zoom. Okay. So let's hear, what do you think for the first one? School personnel are proposing to remove a child with a disability for the first time this school year for 10 consecutive school days. Is that a change of placement under 536? What's your best guess on that? So I see a lot of yeses. Remember, when you look more closely, it's for more than 10 consecutive school days. That's right, the 11th. So it needs to be more than 10. So change of placement equals more than 10 consecutive school days. Could be 11 or more. But 10 is sort of the number that schools kind of keep in their mind. Like, I've got these 10 days that I don't really have to worry about the discipline provisions kicking in. These are the days you may have heard me refer to with much disdain as FAPE-free days, 10 free days. We've heard all kinds of terminology where schools say, for 10 days, we don't have to worry about this. It's, the protections don't kick in for the first 10 days. So keep that in mind. It has to be more than 10 consecutive school days in order to get to a change of placement situation. Let's look at the second one. So school personnel and the parent agree to a change in placement to better address the child's educational, including behavioral needs. Perhaps the child has violated a provision of the school conduct. The parents and the school members agree. Maybe the placement isn't the right placement for this child. We're going to go ahead and change the child's placement to a different placement. Is that a change of placement under 536? So we've got some yeses. The actual answer, I won't let you linger too much longer, is no. If a parent and the school come to an agreement, that's right, it is not under 536. And in fact, we've included an answer to this in question C5 of the Q&A document. This is a long-standing position. It was discussed in the 1999, the preamble to the 1999 regulations, which says, if parents and school personnel come to an agreement, as they frequently do, there's no need to bring into play the discipline provisions of IDEA or something like that. So this is a pretty long-standing position. I'm seeing in the chat. That's right. The IEP would need to be amended as necessary to make sure that it's appropriate for the child's needs and can be implemented in the placement that the school and the parent agreed to. So good points. Okay, so now a tougher one. The third issue, or the third scenario. We've got a child who's been removed during the current school year as follows. So, within just a few weeks' time, we're seeing that this child has been removed for 11 school days. They're not consecutive. The first time there was a physical fight with a peer. The next time, the child disrespected a teacher, may have sassed the teacher, talked back, that kind of thing. And the third thing is the child actually threw a book at a classmate across the room. Would you say that this child has experienced a change of placement now? And it looks like we're seeing a bunch of folks say yes. And I see it could be, but not for sure. And this is where the subjectivity comes in. And right, Sarah, is it a pattern? Do we see, yep, it meets, when we think about the 3 ingredients, it's more than 11, it's more than 10, it's 11. So we've got the first ingredient covered, right? Is the behavior substantially similar? I think that, people could argue and say, yes, this is the same. And the folks who are questioning the amount of time, I just made this up. I don't really know. I don't know of any school that would discipline for this number of days. This is just for purposes of our discussion. But I agree, that would seem like a punishment that is not necessarily commensurate with the violation here. So we've got the first 2 pieces of it, and then the proximity. Look how close together these removals were. If it was November 9 and June 19th, you probably would not be able to say, oh, because of the proximity, we're going to say this is a pattern. But for the purposes of my made up example, these removals are all close in time to one another. And I'm seeing in the chat, this does happen. Even though I made this up, that these kinds of situations do happen for children. So I just wanted to go through some scenarios and get you thinking about, do we have the recipe to make a change of placement or not? And Diane, I'm seeing what you read. I know when I was a complaint investigator in Maryland, resolving a complaint in one of the LEAs, sometimes what folks tell you about what they think is similar or not similar in terms of behavior, can really leave you baffled. But again, talking about a lot of this is subjective. So to the extent, families know what the recipe is and can be prepared to share their thoughts on whether something's related or not related, they'll be in a better position to participate meaningfully in IEP team meetings or meetings with school principals about behavior. So I think that's it for me now. And I think Kim may be stepping up. Is that right, Kim?
That's right. Thank you so much,
Right.
Lisa. Well, wonderful. Hello, everyone. I want to echo Keisha and Lisa in thanking you for submitting these questions to us. We didn't have enough time last time to really get through some of them, and I'm glad that we are carving out this time today to have this virtual conversation. So I have the pleasure of speaking with you. If we could flip to the next slide, please. Thank you. About informal removals, and I'm just going to quickly, hopefully, put here in the chat. As you know, sorry, that's a very long chat, but this is probably information that you already know, right? Informal removals have been described in the glossary of the questions and answers document for the first time. And so what we really tried to do at OSEP was to put a name to a practice that we know occurs. And so we had a few questions come in about informal removals, and I'm sure there are many, many more out there. This is what we have put in the Q&A document really is OSEP's first look at informal removals. So while we may not be able to answer every single question about informal removals, it is really a first step in really acknowledging their existence and really trying to put some parameters around what they mean within the context, especially of discipline. So there were 4 main questions that came in around informal removals, and I'm actually going to take the first 2 questions together. So I'll just quickly read them for you so that you can hear them. The first question was, I am seeing many schools immediately place students on altered or part-time schedules as they figure out what to do next. What is your best advice in assisting parents to advocate for their children to be in school full-time while evals are being completed, especially if the school states that they do not have the resources, such as teachers, to support the students' needs? And then the second question that came in was, what recommendations do you have for families that are told by schools that a shortened day is in the best interest of the child and is not a disciplinary action? So again, for the purposes of today, I'm just going to kind of group these 2 questions together. And to kind of answer them, I want us all to have some additional context. So I think that I know what the authors implied when they were writing these questions, but just so that we're all here at the same starting point, I just want to make clear that a couple of assumptions that we're making when we're kind of responding to this question. So first, I'm assuming that in these situations that the child has already been identified as a child with a disability, found to be eligible for IDEA, their parent consented to receiving IDEA services. And for that first question, I'm also assuming that the child is now presenting behaviors that are interfering with their learning or that of others. And because of these behaviors, the IEP team determined that additional evaluation data was needed to whether it was determined to determine continued eligibility, or maybe it was to inform new special education or related services that that child may need. Either way, I'm assuming that this is why these kind of the evaluation piece was referenced in that first question. And so while these 2 questions are slightly different, I do think there is a common theme here, which seems to be that this child's school day is being shortened solely by school personnel rather than the child's IEP team or their placement team, and that this shortened school day is in response to their child's behavior. So just wanted to kind of get all those assumptions out there, just so that we're all starting from the same starting point. So when I think of that piece, that question of a child's school day being shortened solely by school personnel rather than the IEP team or the placement team, it leads me to the Q&A to section C. And so specifically in section C, question C3 and C6 are questions that you may want to direct parents to when, or school personnel to, when you're grappling with these types of circumstances. So I wanted to highlight a couple of parts of questions C3 and C6 that I thought might be helpful for you in these conversations. So the first thing I wanted to highlight was that in question C6, it states that the practice of shortening a child's school day as a disciplinary measure could be considered a denial of FAPE if the IEP team doesn't also consider other options, such as additional or different services or supports that would enable that child to remain in school for the full school day. So that's one point that you may want to remind both school personnel and families of. The second piece that I wanted to flag in question C6 is that it also says that in general, the use of informal removals to address a child's behavior, if implemented repeatedly throughout the school year, could constitute a disciplinary removal from the current placement. And then therefore, IDEA's disciplinary procedures would kick in. And this would apply generally unless the kind of 3 criteria that we referred to in the first webinar that we had last month these kind of three factors are met, right? One is if the child is afforded the opportunity to participate and continue to appropriately participate in the gen ed curriculum. The second is that the child continues to receive the services that are specified on their IEP. And the third piece is that the child continues to participate with non-disabled peers to the extent that they would have in their current placement. So I wanted to flag that. Sorry, Lisa's not the only one getting over the flu, so sorry, hold on. Okay, apologies. The next point I wanted to flag for you was in question C3. So in C3, it states that the frequent use of short-term disciplinary removals or informal removals of children with disabilities may indicate that the child's IEP is not appropriately addressing their behavioral needs, and that may result in a denial of FAPE. So, you know, hopefully, right, with kind of pulling out these pieces, these relevant pieces of these questions within the Q&A, when you have a situation where this child's school day is being shortened solely by school personnel rather by the IEP team or the placement team, you'll be able to share with families and with school personnel these kind of very relevant pieces that they need to consider when it comes to whether this may be a pattern that results in a disciplinary removal, whether this results in a denial of FAPE, and whether this should prompt an IEP team to gather together to really look at whether that child's behavioral needs are being addressed. Okay, so the next part of those first two questions really ask for some advice. And while we don't necessarily provide advice in this way, what I would say is that, you know, just kind of like what I referred to a minute ago, I think this is a good opportunity and space to remind school personnel and families that of IDEA's requirements that address a child's behavioral needs, right? FAPE is tied to addressing behavioral needs as well. We address this in section A of the Q&A. So you can also go and reference that section as well. PAVE has a wonderful set of resources on their website that we put in the chat earlier that address behavioral health, that, you know, sharing resources like that among your PTIs may be helpful so that you can be able to provide parents with that type of support in when it comes to behavior. So that's one thing. The second piece that I think would be helpful to remind families of is that, as you of course very well know, you know, families can request an IEP meeting at any time. IDEA permits that. Third, I think it would be great to remind families that IDEA requires prior written notice whenever the public agency proposes or refuses, right, to initiate or change the identification, evaluation, or educational placement of a child, or for the provision of FAPE to the child. So it's important that prior written notice be also part of this conversation. And lastly, I think it may be helpful to remind families that, you know, I think one of the second question I think asked, you know, in terms of the best interest of the child, you know, this is hard, right? IDEA doesn't really talk about what's in the best interest of the child. It's difficult because IDEA is at its core a civil rights law, but what it does is it really talks about the obligation of LEAs to provide FAPE. And so while that's a kind of a nuanced distinction, it's important for families, I think, to know that going in, that the obligation is to provide FAPE, and that when LEAs are making these proposals, that they should be able to provide an explanation about how this proposal will enable them to provide FAPE to the child. So I hope that gives you a little bit more direction or ways or strategies to support families when it comes to addressing those shortened school day conversations. So the next question that came in was really around in-school suspension. So the question was, does OSEP consider in-school suspension to meet the criteria of students participating with their current placement? And so I believe this question is asking whether in-school suspensions would be considered a school day that must be counted when determining whether a removal constitutes a change in placement. And so OSEP addresses this issue directly in question C7 of the Q&A. And so basically, it's been OSEP's longstanding position that an in-school suspension generally would be considered part of the days of suspension unless the child is, one, it's these three things I mentioned just a minute ago. One, if the child is afforded the opportunity to continue to participate in the gen ed curriculum. Two, if the child is able to continue to receive the services specified on their IEP. And three, if the child is able to continue to participate with non-disabled children to the extent they would have in the child's current placement. So if those three things are met, then generally we wouldn't think of that in-school suspension as a day of, counting towards the removal days. But we believe that to be a pretty high bar to meet all three of those criteria. And so if those three criteria are not met, then it would count as as one of the days towards the removal. So I just wanted to flag for you that that is in question C7. Okay, so the fourth question is, and this is a great question, and I know it's one that we will continue to receive. Do informal removals can include removals from field trips? And I'm going to be very upfront here. OSEP's discipline guidance doesn't directly talk to this specific issue, but I did want to flag for you, and I'll put this in the chat in a minute, that OCR's guidance, discipline guidance, does reference exclusion from field trips as an example of one of the ways that they know they have heard that informal removals occur. And so I will drop for you a link in the chat to where OCR kind of references this. I think this will be an area that we will have to really explore deeply because I know it will be something that will continue to occur. But it is, I think OCR's guidance might be a much more direct way of looking at this issue for this time being. So I'm not sure if any additional comments came in the chat around informal removals. Again, like we said, this is the first step in really looking at this issue. So we would really encourage you, as you're on the front lines, you're hearing from parents constantly, please keep those lines of communication open with us. Through Carmen, you can always, share with her what you're hearing. She will share it with us, or of course, you can share it directly with us as well. But we want to know what's occurring in this area, in this space, so that we can be as responsive as possible. So with that, I actually think I turn it back over. I will drop a few things in the chat in a minute, but I will turn it back over to Lisa to talk about parental rights and in the context of the discipline guidance.
Okay, you got me again. Just looking at the chat, and I know we've all heard of situations where, as a discipline action, really, well, then you can't go on the field trip because of this. You can't join the field trip. So we know this is something that does occur. Kim, thank you for doing the research with what OCR stated directly about this, and it sounds like we might have some catch-up work we need to do. So let's move on to the next slide, please. I want to get one good cough out. Hang on just a minute. Okay, I'm glad I did that so that hopefully I can get through the rest. So there were a number of questions that we received about whether LEAs are permitted to act in certain ways, going straight to an expedited due process hearing and not necessarily following IDA's discipline procedures, and some questions about are they really permitted to do that? And we thought it was important to highlight some of the parental rights in the context of a disciplinary removal. And in the procedural safeguards document, if you look at the link, what's hyperlinked in the very last sub-bullet on this slide, when IDEA 2006 regulations came out, Congress had required that we, the department, develop a model form that states could use for procedural safeguards. So many states have modeled their procedural safeguards notices after our model form, but just wanted you to take a look at that. So if you ever had a few spare minutes and you wanted to compare your state's form with the model form, you could do that. But part of the required content in a procedural safeguards notice is to make sure that parents are informed of their rights in the context of discipline. And certainly in the last session, we talked a little bit about the special circumstances where a child may have brought drugs, weapons, or, trying to think how to say it. There was serious bodily injury involved in the child's behavior. That in those cases, LEAs can go straight to disciplining the child as they would other children without regard to whether the child's behavior around those three areas, drugs, weapons, serious bodily injury, were a manifestation of their determination, a manifestation of their disability. Sorry about that. LEAs don't even need to go to an expedited due process hearing in those cases. The regs allow them to immediately remove the child, place them in an interim alternative educational setting without going through all of the procedural steps that we've talked about under IDEA. They still eventually will need to do some of those things, but they would do a manifestation determination, but they don't have to wait to follow those procedures. And IDEA also allows an LEA to request an expedited due process complaint, a hearing, if they believe that maintaining the child in the child's current placement is substantially likely to result in injury to the child or to others. But in order for an LEA to ask for that kind of expedited due process complaint, there has to already have been a manifestation determination where the team would come together and say, it is a manifestation of the child's disability, and the LEA basically says, well, I know I'm supposed to return the child to their current placement, but I'm afraid they're going to injure themselves or others, so I'm going to go seek a hearing officer's decision on this matter. So typically there will have been a manifestation determination before the LEA files that expedited due process complaint. I suppose it's possible they could go straight to a hearing officer, just as, and this isn't something we've publicized a lot, it was in a Q&A document in 2009, and the 1999 Part B regulations, the preamble to that addresses that an LEA can seek a temporary restraining order from a judge in exigent circumstances. So again, this is not something we would expect to occur frequently, but if a school believes that what is happening with a child, that the situation is such that child's attendance at their current placement would pose such a danger to other children and to the child himself, the school community, they could go straight to court and seek a temporary restraining order or an injunction, something like that. You've probably heard of that happening occasionally. Again, not something that we would expect to happen, but LEAs and those really, which should be rare circumstances, where they believe that a child's attendance in their school, in their regular placement, poses such a danger, to a chance of injury, substantially likely, to injure the child or others. They can take those, extraordinary means. So I did want to share that with you today. Again, it's not highlighted in the guidance. It was in some past guidance. I think we had received some feedback that it wasn't necessarily helpful to profile it so openly in some of our guidance, but I know that it is there historically. If LEAs believe that that's the action that is necessary. So what are the specific rights IDEA affords parents when their child has been subjected to a removal for disciplinary reasons? Well, we know that a copy of the procedural safeguards notice must be provided when the agency is proposing to change the placement of a child. As I said earlier, that notice needs to detail parents, what their rights are. As I said earlier, if there is no change of placement, but the child's been removed, but it doesn't meet doesn't have all the ingredients for the change of placement recipe, I'm sorry, the parents, may not get a notice. Now, OSEP had encouraged LEAs to give parents notice of removals, even if it doesn't constitute a change of placement. But IDEA does not, as the regulations are, actually require them to do so. When a public agency and parents meet to do the manifestation determination for a child who has been subjected to a change of placement for disciplinary reasons, if the parent disagrees with the outcome, the decision that's made, they can appeal that decision. If they disagree, again, another right, if they disagree with the placement that the public agency is proposing during the period of disciplinary removal, including the setting and the services, they have rights to dispute those decisions. We typically think of the rights coming primarily from 300.532, and that's the specific regulation about appealing discipline-related issues, expedited due process complaints. But as I believe Kim said just a few minutes ago, and one of the things we wanted to make clear in the Q&A in Section K is that even though IDEA provides these special hearing procedures for discipline matters, those same matters can also be brought through the state complaint process. The parent can request mediation, which we know has to be voluntary, on the part of both parties. So they have avenues other than requesting an expedited due process complaint. The expedited due process gives sort of an extra, hopefully shorter process, but I have to tell you, even though it's called expedited, it depends on when it is filed, because timelines for expedited due process complaints are measured in school days, not calendar days. So, summer schedules, holiday breaks, things like that, it may or may not actually be much faster than, the regular sort of garden variety due process. So I think we are at 4 o'clock now. Can we go to the next slide? And I think it should be our closing slide. Yes. At the beginning of the presentation, you were able to have information about our names and our did we give any email addresses? I can't remember. I am only here until December 30th. I'm retiring from the department the end of this year. So if you've got burning questions before then, you can find me. After that, feel free to send them all to Kim and to Keisha. And thank you again for having us today. I've certainly enjoyed my work with the PTIs over the years and appreciated all the opportunities you gave me to meet with you and learn from you. So thanks so much.